What happens in Arizona if someone dies without a will? Hi, I'm attorney Paul Delaw, and I'll answer that question in 3 simple, fast steps so you can avoid confusion, conflict, and court delays. Step number 1, what happens without a will? Well, here's the shocking truth. Over 60% of Americans don't have a will, and that means most families are forced to navigate a legal system that they weren't prepared for. So imagine this. Your loved one passes away, and suddenly Arizona law decides who gets what. No discussions, no compromises, no clarity. That's called dying intestate, and it activates a hidden set of Arizona laws that most people have never even heard of. Step number 2, let's discuss Arizona's intestacy rules. So first, let me mention that this only applies to probate assets. This only applies to assets that were in your deceased loved one's name when they died. It does not apply to assets where there is a surviving joint owner, or maybe there is a beneficiary designation. For example, life insurance typically doesn't go through probate because usually there is a beneficiary on life insurance. So anyway, we're talking about probate assets. Now in Arizona, if there's no will, a legal pecking order kicks in automatically. Married with no kids, your spouse gets everything. Married with kids from that marriage, your spouse still gets everything. Blended family, now it gets tricky. Your kids could be splitting your estate with your spouse. No kids and no spouse? Well, your parents, siblings, or even distant cousins might inherit. And yes, under certain rare circumstances, even someone you hadn't spoken to in years might get a piece. Okay, step number 3, what happens in probate? Well, with no will, someone has to file with the court to open probate, either formally or informally. They're filing documents, they're paying a filing fee, there might be a hearing. You can expect some level of court supervision and legal notices to other heirs, other family members, and a waiting period, usually at least 6 months, but often longer. There are also fees, court costs, legal representation, meaning hiring an attorney to help you through the process, and possibly even posting a bond, which is a kind of insurance policy to help ensure that the estate is handled properly. Now, even simple estates are not immune to red tape. The process is full of forms, deadlines, and decisions that must comply with Arizona law. Once probate starts, the court ensures that assets are distributed according to the Arizona statutes, not family promises, not personal wishes, and despite all that, disputes happen all the time. Heirs challenge decisions. Someone might claim the decedent was coerced into making a handwritten will on a Christmas card. Yes, that's a real case I handled. Minor children's inheritances are another complexity. You see, Arizona law requires safeguards such as court-appointed conservators or conservatorships to protect a minor child's interest until they become adults. And then, great plan, when they turn 18, they get a big windfall. So none of that's a really great idea. Now, if you found this helpful, give this video a like and subscribe for more real-world probate advice from someone who's handled 1,000 Arizona estates, over 1,000. And if you're dealing with a situation where there's no will or want to prevent your own family from ever facing that, simply visit probatemadesimple.com today and give us a call. Thanks for watching.